federal privacy laws don't apply to every business. You need to be able to understand the applicable threshold. Hello everyone and welcome back to Privacy Professional Training. My name is Fumi Owolabi. In today's video, we're going to be focusing on Domain 2 again of the Certified Information Privacy Professional of the United States, which is a certification that is offered by the IAPP. And in this domain, we're going to be looking at federal privacy laws in the United States. One thing that I think is of value to know for this particular domain is you're going to be able to really dive deep into the structure of US privacy law. So if this is your first privacy certification, you're going to realize that unlike other jurisdictions and unlike other countries, the US doesn't rely on a single comprehensive privacy statute. The United States uses a sector-based and activity-based approach to privacy. And something that's evolving in the last 6 to 7 years is there have been more and more US state privacy laws too. In today's video, we're going to be looking at federal privacy laws. The first federal privacy sector is the education sector, and this is addressed in Domain 2. And essentially, education privacy is an area that looks at statutes related to personal data and education. The primary federal statute that we're going to be looking at is the Family Educational Rights and Privacy Act of 1974. And the acronym for that is FERPA. And this law regulates access to and disclosure of student education records. Now, FERPA applies primarily to educational institutions and in certain cases to service providers acting on their behalf. So in this domain, we're also going to highlight the privacy implications of education technology, especially when student data is used for purposes beyond instructions of the administration. So you're going to need to be able to understand the instructions that might be offered by an administration and what FERPA requires under the law. In thinking deeper, students should consider what qualifies as an education record. You need to be able to understand this concept very clearly, and the role of directory information. In other cases, when vendors may be treated as school officials. It may also be helpful to reflect on how parental rights shift to students over time, depending on age, right? You need to be able to understand this very clearly in the law. There are some nuances that show that education privacy depends on both role and relationship. You need to be able to make the distinction in that respect. The second area that we're going to talk about today is telecommunications, marketing, and digital privacy. These are addressed in Domain 2. So there's a broad category in this domain that covers these specific areas. Now, telecommunications, there's lots of things that could constitute. And in this area, there are some of the laws that you might encounter during your review. The Telephone Consumer Protection Act of 1991, also referred to as the TCPA, and the National Do Not Call Registry. Understanding the rules associated with this type of telecommunication is going to be vital. Same with the Do Not Call Registry. Another law in this area that you're going to encounter is the Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, also known as CAN-SPAM. And you may have heard of either of these laws in disclaimers that are offered by other businesses for products that you consume. The Video Privacy Protection Act of 1998, the VPPA, and the Driver's Privacy Protection Act of 1994. So there's lots of laws in this respect because there's lots of telecommunications. And these laws often regulate how organizations communicate with individuals rather than how data is stored internally. And in this domain, you're going to see references to modern issues such as digital advertising, web scraping, and data ethics. And that illustrates how all of these older statutes are applied to newer technologies. You need to be able to understand what type of technology is being used in the telecommunication space and how it's applicable to older statutes. In thinking deeper, you could reflect on how consent standards differ depending on whether the communication occurs by phone, text, email, or other channels, and making that distinction between prior express consent and prior express written consent, right? Making the distinction under the Telephone Consumer Protection Act. And this is a really useful way to be able to analyze when the question arises and knowing the distinction between both. It may also be helpful to consider statutory exceptions such as emergency communications and how legacy laws are interpreted in modern contexts. Another key concept are enforcement themes. What happens if there's a violation and who is the enforcer? Now, from a federal perspective, there are different types of enforcers. I mentioned in the video before about the Federal Federal Trade Commission. There are also enforcers that are sector specific, and then there are other federal agencies that conduct the enforcement. It's really key to note that not all laws provide individuals with a private right of action. So you need to be able to identify which federal laws do private right of action and understand what a private right of action is, and then what the compliance risks are for an organization if they materialize. In thinking deeper about this, you may benefit from reflecting on the role of a consent decree, administrative penalties, and enforcement discretion, making the distinction between the three. Now, these tools often shape organizational behavior more significantly than statutory text alone. So what is influential on the business? Because essentially you're trying to be a privacy professional, right? What would a privacy professional do in this instance based on this federal law? It's also really important to understand the limit associated with Domain 2. So let's talk a bit about federal privacy laws. Generally, they don't regulate all personal data. We talked about how in the US, privacy is fragmented based on different factors and qualifying personal data. In addition to that, federal privacy laws don't apply to every business. You need to be able to understand the applicable threshold in each federal law that applies. And also making sure that you understand that there is no single national federal regulator, right, in other geographies. If this is a secondary exam to you, it may be that you're familiar with geographies where there is one regulator, but in the US, that's not the case. So let's talk a bit about why this domain matters in your studies and why I think it's valuable to really be able to make these distinctions up front. In this domain, you're encouraged to think analytically about the key concepts associated with each federal law, and they help with the foundation with other domains where you're going to experience differences in US state privacy law to federal laws. You could be considering what type of data is at issue for a specific federal privacy law, which federal law could apply in a specific scenario, and which agency is likely to enforce a specific federal privacy law. So this reasoning-oriented approach aligns very closely with how Domain 2 is structured. So as you continue preparing for the Certified Information Privacy Professional of the US exam, you should be thinking of Domain 2 as a foundation to understanding how privacy works in the US, and then also how it aligns with real-world scenarios as it pertains to organizations in the United States. Basically, to sum things up, the laws are targeted, risk-based, and enforcement-driven. Understanding their scope and limitations are going to help you approach privacy issues with clarity and confidence. In the next video, we're going to move to Domain 3, which examines government and court access to private sector data. I really hope you enjoyed this video, and I will see you in another one.